The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Hi, this is Heather Jones, a family law attorney with O'Flaherty Law, and today we're doing a how-to video for filling out a petition for appointment of guardian ad litem. This is a video that is for educational purposes only, and it's not meant to be legal advice or be in substitution of legal advice. If you're having problems with your Wisconsin divorce or family case, you should always consult with an experienced Wisconsin family law attorney to help guide you to your legal goals. However, this is a sheet from the Wisconsin Circuit Court Forms Bank, and it does provide some instruction here on the left-hand side of the sheet on how to fill out the form. And this how-to video is just to help clear up any questions that are left unanswered by the instructions given on the sheet. So this is Form FA-4136V. Again, it's a petition for appointment of guardian ad litem. Some people don't understand what a guardian ad litem is. In this particular circumstances, a guardian ad litem will be a licensed Wisconsin attorney who is appointed to represent the children's interests in the divorce case. And we'll go through some of the reasons below. They're given in the form. A lot of people ask who pays for the guardian ad litem, and that is up to the presiding judge over the family case. A lot of the time the judge will split the cost of the guardian ad litem between the parents, but if there's a different set of circumstances to look at, for instance, one parent is currently unemployed or one parent earns a significantly higher amount of income than the other, the court will take that into consideration. The big thing to remember is that once a guardian ad litem is appointed, it is very difficult to get a different guardian ad litem appointed. So if one is appointed and you don't like them, usually you can't get rid of them once they're there. The guardian ad litem has the right to ask questions, to interview, to speak up in court proceedings, to examine the facts and circumstances presented at the time, and the guardian ad litem can even give opinions on financial matters within the divorce if they affect the children. So those are all things to keep in mind prior to asking the court to appoint a guardian ad litem. So starting at the top left-hand corner of the form, depending on whether or not it was a petition for divorce or a joint petition for divorce, you will put your name and your spouse's name on the appropriate lines, and you'll see this on each sheet of the form. That's just to help keep everyone organized and know if the piece of paper gets loose, know who the form belongs to. At the top right-hand corner of the screen, you'll see that this area is blank. Don't put anything there. Don't staple the form there. That space is meant for the clerk of courts to file stamp the document. You'll go ahead and enter whatever county you filed your petition for divorce in, or it could be also for a paternity action. This is kind of a catch-all form, so it would be in regard to the marriage of, or if it's a paternity case, you can ask for a guardian ad litem. And here you would just put the child's initials. That is how paternity cases are identified in the state of Wisconsin. Full name of both adult parties. And then you should already have a case number because something's already been filed. So here you have the option to check A, B, or C. So let's go through the options and talk about what they offer. So Section 1, I ask that the court appoint a guardian ad litem, or a GAL, for one or more of the minor children and believe it is appropriate now because, and then we go to option A, one of the parties in this action believes that an unborn child or one or more of the minor children born during the marriage is not a product of the marriage. And that option speaks for itself. Option B, there is an ongoing legal custody or physical placement dispute between the parties that will require the appointment of a guardian ad litem because, 1, this matter has been referred to family court services for mediation and the process has been unsuccessful, so you and the other party just can't come to an agreement about custody or physical placement of the child or children. Or 2, this matter has not been referred for mediation because I believe that attendance at an initial session of mediation would A, cause undue hardship to usually yourself if you're asking for it, and then you give the reason. And it doesn't say this here, but if this line is not enough room to explain your situation to the court, you can always just put see attached and put it on a separate sheet of paper. But whatever you do, don't alter the form. Don't get fancy and add more lines or do anything like that. Just put see attached and put it on a separate sheet of paper. So that's one reason you would give the court for not attending mediation. Another reason that you would be unwilling to attend mediation in either a divorce or paternity action would be that attending it would endanger the health or safety of one or both of the parties or the minor children because sufficient evidence is available to show, 1, a party has engaged in abuse of the minor children as defined in chapters 948 or section 813, 122 of the Wisconsin state statutes. And you can Google those and find out exactly how the state lays out the elements of what abuse is under the state law. Abuse of minor children. 2, there's been interspousal battery as described in chapter 940, or domestic abuse as described in section 813.12 of the Wisconsin statutes. Or you can also say one or both parties has or had a significant problem with alcohol or drug abuse. And you're not limited to just picking one. You can have all three, but you need to have evidence to back it up. So whatever you say here, you have to have something other than your testimony showing that there's been abuse or battery or substance abuse issues. So moving on to section C, there is good reason to appoint the guardian ad litem now rather than waiting until mediation has been completed because, and again, one line here is probably not enough room to explain to the court why you think the guardian ad litem should be appointed now. So once again, you could just hit see attached and explain on a separate sheet of paper that you would attach to the petition prior to filing it. So section 2, obviously, they want to know who the minor children in question are. You give their names and their date of birth. Section 3, they want the name and address of the petitioner or joint petitioner A. And they also want the name of the respondent or joint petitioner B. And again, as we said earlier in the video, you're also going to want to put your names at the top left-hand side of every sheet of paper included in this form. The court also wants to know if you've ever had a guardian ad litem in this set of circumstances. So they want to know if a guardian ad litem has never been appointed for the minor children in the past, or if one has, and if they were, when and who were they? They might go for the same person because that person would have some background information and knowledge regarding your family and the family situation. So just be as clear and concise as possible. If you don't remember, if a guardian ad litem was appointed, there should be a case. The guardian ad litem was appointed in. You could always go look it up on CCAP, get the information, get the date of the appointment. And then again, if you don't remember the date or their exact name, that's okay. Just do your best on this section. Number 6, remember again in the beginning of the video, I answered the question, who pays for the guardian ad litem? And here's your little warning here. I understand that the court may order one or both parties to pay guardian ad litem fees. Now the court could split it in half, or the court could have one party, or could do like a 60-40. Just depends on the financial circumstances that you and your spouse or partner are currently in. So just be ready to pay something. Moving on, if no objection is filed with the court within 5 business days after this request is served on the other party or their attorney, I request that the court appoint an attorney admitted to practice law in this state to act as guardian ad litem for the minor children. If an objection is filed, I request that a hearing be set on this petition. So, if they file an objection, you're going to have to go and appear at a court hearing and basically restate your reasoning that you give in the petition. And obviously, if they object to the appointment of a gall, they'll say why they object, and just be ready to answer whatever reason they have for not wanting a guardian ad litem. Just be ready to argue about it. Obviously, they'll file the objection so you'll be able to see why they're objecting and prepare your arguments accordingly. This is just a standard warning. If a hearing date is set, if you require reasonable accommodations due to a disability to participate in the court process, please call. And there's a space here for a phone number. You'll know what county you're filing in, and the county court website will give you either the number to call to ask for reasonable accommodations, or you can call the clerk of court office and ask them what number someone is supposed to call if they require reasonable accommodations, and put that phone number here. And just tell them that you're filling out a petition for appointment of guardian ad litem and that you need to know what phone number to put in this box, and they should be able to give it to you. This is not a notarized form. It's not a sworn statement, so you would just sign, print, address, email address, and attorneys use these forms too, so they do leave a spot for a state bar number, but obviously if you're doing this on your own, you don't need to worry about that. So once again, as we've said throughout the video, whatever you do, if you run out of space, don't modify the form. Just supplement with an additional sheet of paper. And that is Form FA-4136V, Petition to Appoint a Guardian Ad Litem. Thank you so much for watching. To learn more about divorce in Wisconsin, you can visit our page. It's linked below. And please be sure to leave any questions you have in the comments section, and subscribe for more legal content daily.
Hi again, this is Kevin O'Flaherty from O'Flaherty Law. I hope you enjoyed the video and podcast. If you did, I'd love it if you'd subscribe to our channel. If you need legal help in this or any other area of law, please don't hesitate to reach out to schedule a consultation. Most consultations are free and can be conducted remotely if you'd like. You can email us, book online, or call us at 414-253-2080. That's 414-253-2080. We have many locations for your convenience, and we serve all of Wisconsin. Thanks again for watching.